Good morning, sir. Are you Hakeem Thomas?
Yes, ma'am.
And Mr. Thomas is charged in cause number 25 DCCR 0843 with the first-degree felony offense of aggravated robbery. And Mr. Lewis has filed a motion asking that I reduce the bond, which is currently set at,
I think 600,000.
okay. And Ms. Malfino, you have a witness. Do you want Ms. Malfino to go first? Would you rather go first, or?
No, I prefer she can go first.
Go ahead, Ms. Malfino.
Okay, Judge, just for purposes of the record, I would tender to the court just for ease of use, State's Exhibit Number 1, which is a probable cause affidavit in this case, and I will call Detective Candy.
Any it's in my file. Do you any objection
No
to,
objection.
States 1 is admitted for purposes of this hearing. Good morning, sir. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. Go ahead.
So, you can see both of us. Could you please state your name for the record?
Dwight Dean,
And how are you employed?
Beaumont Police Department,
How long have you been in the city of Beaumont?
31 years.
You're a certified peace officer in the state of Texas.
Yes, ma'am.
And you and I discussed this case involving Hakeem Thomas as well as his co-defendant Tyree Hartley last week. And we're here in order to address the bond in this case. Can you briefly go over your involvement in the case and your familiarity with the facts in this case and why you think it's important that this defendant remains in custody?
My involvement is through Southeast Texas Outfit Task Force. We deal with auto murderers, and a new offense as was added to our penal code called judging. We believe that this offense started out as a possible judging on breaking into a car, and which ended up into injury with two of the guys involved. One standing here as well. That ended up injuring an infant child through coordinated efforts of us locally here in Beaumont, myself, officers on the street, along with deputies of the Chambers County Sheriff's Department. We're all involved to have these guys arrested.
So they did actually flee from this jurisdiction into Chambers County after this offense, which again involved an infant child in the back seat of that car being injured when they attempted to break into that car and retrieve the money that the child's mother had obtained from the ATM.
That's correct. The ATM of the bank, that the vehicle, the dad left the vehicle, and the mother and the infant child were in the back seat of the car. Not only did they break into the car with shattering glass on top of the baby and the mother in the car, with her continued efforts during the crime itself, they didn't stop. They kept on. Once they were successful, if you could say that, in any kind of theft, they did flee from here and were actually found in the same vehicle.
And did you subsequently with Detective Andrew learn that both of these defendants in this case had committed similar types of acts in various jurisdictions across Southeast Texas, Harris County, Fort Bend County, Austin, etc.?
Yes, ma'am. Some of it did happen that actual day, and then of course some of it was put together, shredded in the background, and those are after the arrest.
And is it your position, based on all of your years of training and experience as an officer here in Jefferson County, Texas, that to maintain the security and well-being of the safety of the citizens of Jefferson County, that it be best that pending prosecution of this offense, this defendant at least remain with some kind of a high bond from this court?
Yes, ma'am.
Thank you. I'll pass the witness, Judge.
Thank you, Mr. Lewis.
Yes, just briefly. Now, you said you were definitely part of the investigation of this allegation, correct?
That's correct.
Now, during your investigation, was it ever shown that a weapon or any deadly weapon anything was exhibited to the plaintiff witness? Or
Not that I'm aware.
So there was no weapon involved as far as we know?
Not that I'm aware.
Okay. And as far as your investigation as it relates to my client, was it any statements or evidence that showed that he was involved with the actual breaking of that of the glass or possibly injuring the child involved?
Not that I'm aware.
Is there any evidence that would show that they even knew it was an infant child in the car at the time?
No, it's not.
Okay. I'll pass the witness, Judge.
I've done further, Judge, this argument.
Thank you, Officer Dean. Any witnesses, would you wish to call your
No.
client with regard to his financial status? Mr. Thomas, come back around. Best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, go ahead.
Mr. Thomas, as far as your financial situation, you're currently in custody, correct?
Yes, ma'am. Yes, sir.
Now, do you have any money saved up that could be used for your bond?
No, sir.
Do you have any property that could be sold or vehicles or anything of that nature that could be sold in order for your family to come up with your bond?
No, sir.
Who would be responsible in trying to come up with the bond amount for you?
My mother and my wife.
Your mother and your wife? Have they been in touch with any bondsmen
Yes,
currently? Okay. And from the information you received, how much of a bond or commitment they will be able to make to try to bond you out?
Complete bond amount, between $70,000 and $100,000.
Between $70,000 and $100,000. Okay. Now, were you employed before you came to custody?
No, sir.
Do you have any employment or anything available to you if you're able to make bonds?
Yes, sir.
And what would that be?
Being a helper to my wife's father in his CDL truck.
Okay. And that will give you enough money to be able to take care of any pretrial conditions or anything you need to do with
Yes,
your representation in this case?
Yes, sir.
Okay. I pass the witness no further.
Ms. Malfino?
Mr. Thomas, tell the judge a little bit about your criminal history, starting when you were a juvenile.
I have no juvenile record.
Were you in trouble as a juvenile over in Harris County?
No.
What about your theft, your state jail felony theft from a person, which is basically another way of saying,
That's
who
not
did you
juvenile,
wrong?
no.
Don't talk over her, okay? Just wait till she's finished talking so the court reporter can take one at a time.
Yes, ma'am.
Where was that?
Go ahead, Ms. Malfino, you might want to read.
Your theft from a person, which is basically a robbery, where was that?
2021,
Where? In Harris County?
Rosenberg.
Have you been in trouble in San Antonio?
No, ma'am.
Have you been in trouble in Austin?
I have a pending case in Austin right now
For what?
for a robbery.
Do you have any kids?
Yes, ma'am.
Someone would have done this to your wife and your baby would have been in the car, what do you think that person should get? Prison time?
I don't understand this.
I don't have anything for you, Judge.
All right, anything else?
Nothing else for this witness, Judge.
All right, you may make argument.
Judge, as far as this case goes, you've seen that it is charged as aggravated robbery, but it's one where we don't have a deadly weapon involved or anything like that. The biggest issue, I think, with this situation, of course, is my client does have some criminal history and lives out of county. I believe there's already some bond conditions in place for him to have the GPS monitored and be able to go to be in Harris County, come back, of course, for court and everything. We are asking for a bond in between $75,000 and $100,000. I think that, including with the GPS monitoring and everything, would be enough to cover, one, secure his return to court, and also, of course, satisfy any public safety concerns while these cases are pending. He does not have a hold for the case in Austin, because I believe he's still in bond for that
I
situation.
find out when I'm being custody.
Right. So he is on bond for that, so he will be allowed to be released. My understanding, there's not been a court date set up there. We don't anticipate that interfering with us here as far as any type of issues. And from
When
talking,
did you make bond on that case?
July, sometime in July.
Okay,
I'm not sure the exact date.
Okay, that's
sometime
fine.
in July.
all right, go ahead.
But from talking with his family, they have been involved with this case he has going on up in Austin, and that I think that actually will be resolved pretty quickly, and won't interfere with what we have going on here.
What, if anything, and Officer Dean may know about, I know you noted some other counties where there were some potential cases or issues. Do you have any other information on those?
I have reached out to Fort Bend, Judge. I have had difficulty in getting a final answer. A charge looks very looming. How they initially filed them, I think one of the impediments that I'm up against is in Harris County, Fort Bend County, that surrounding area. They have dropped a lot of stuff down to some very low amounts of time. So it looks like if an initial charge comes in as an aggravated robbery, it ends up 6 months later as theft from a person in the state jail. So that's really the totality that I've been able to.
Do you have any other
obtain from
additional
the
information?
co-defendant.
No, ma'am, that's exactly what I was gonna say. It looks like there's been some initial charges that were actual aggravated charges that were bumped down.
Okay.
And I would also ask if you would take judicial notice of his incident and behavior report.
I will. I also have, and I think you guys should have received 7 pages of incident reports from the jail as well, which obviously y'all know my thoughts on that. And so anything else?
No, Judge, and the state does not object relief necessarily in this case, just not, I would ask that it remain in an amount at least above $350,000.
And Judge, if I may, to the jail incident reports, I think those were like early on when he got into custody. Of course, me and Mr. Thomas did speak about those and how, of course, he should conduct himself out there, and I don't think that he has had any other issues since that conversation.
I guess my concern, and I understand from the probable cause that the allegation is that Mr. Thomas was the driver of the car, but I don't know that that makes it any better whatsoever, because it doesn't sound like there's any evidence on why he and Mr. Hartley were in Jefferson County, if they're from Harris County and that's where he's going to live, why they're in Austin, why they're wherever they are, other than to come into our county and break into people's cars or jug, which has become a huge issue. And so based on the evidence today with regard to the specific offense, based on the jail incident reports, based on the information received through, again, take judicial notice of the court's file, the magistration information as well, the fact that there is at least one pending case that is similar, others that sound similar, just with some different outcomes, I don't think it is in anyone's best interest that Mr. Thomas have any relief today, and so I'm going to deny the motion to reduce the bond. We will reset the case and for an announcement and see where we get. All right, thank you, sir, for being here, Mr. Kane, Officer Kane. All right, do I have a, good morning, you're Roderick Randall? And this is cause number 24, DCCR 0543, and Mr. Randall was previously in court, entered pleas of true and a motion to revoke probation, pled true to counts 1, 2, 4, 5, and 7 and 8 on probation for the first-degree felony offense of aggravated robbery. And I've received the pre-sentence report update. Have you all had an opportunity to review that?
We have, Your Honor.
I have, Your Honor.
Are there any additions or corrections?
No, Your Honor.
Well, Judge, I noted probation's opinion that continuing on probation may not be a good idea. And I know we'd agreed on ISF in an attempt to keep him from being revoked. I understand if the court feels differently.
I didn't know that that was an agreement, and if it was, I show that you are asking for that, but I didn't think
And
the state.
I think what I stated
that
was I wanted to see the PSI
Yeah.
and get an idea of what has
The
really
new-
happened or not happened on probation.
Well, he pled true, I mean, on probation for a case, an aggravated robbery that involved shooting out the window of a car at someone after having stolen stuff from that person. New offense, pled true to being arrested for unlawful carrying a weapon and evading arrest or detention. So, I'm not inclined based on, you make argument, Mr. Rojas?
Yeah, Judge, and my understanding was that it wasn't agreement for ISF, but and if it wasn't, then obviously the court can do whatever the court feels is appropriate.
Can you look, pull up that paperwork? What was the date of, it's not finalized, so the plea paperwork should still be somewhere on the tablet.
August 26th.
If you can get 826 pulled up, do you know how to do that? And send it to me, send his paperwork to me, please. And if that's what y'all's understanding and you need some time to prepare for a hearing, I can reset it for a couple of weeks, if you want to do that as well. But let's see what the paperwork said first.
I think we discussed it, and I said I want to wait and see what PSI says. I'm gonna, let's double check.
Okay.
Yeah. Really?
It is marked off on an agreed punishment recommendation, ISF cognitive, but it doesn't say wait or anything like
Okay.
that, but I don't know that I'm inclined to do that. I mean, what is the status of, are those cases down in misdemeanor court?
They're still pending, Judge. He's been appointed, Mr. Cole, to be his attorney, and I talked with him about the issue that he's inclined to go down and plead those cases once this is all taken care of.
I would like to know, at least see a PC on that new arrest.
I
If you
right here,
have
Your
it, you do?
Honor. Yes, Your Honor.
Any objection to me?
No objection.
doing that? No. On probation for an aggravated robbery And if I recall, I don't know that it was ever on, when I tried to go back and see, nobody really said or could tell for sure who shot out of that car that night. But if I'm correct, I feel like Mr. Randall, who was in the back right passenger, was potentially, it was out of the back.
Judge, I feel like because I remember this case, there was four
There's
individuals
four.
in the car.
Did anyone?
I don't think I would have lowered his to a non-aggravated if I believed that he was the shooter in that case.
They did gun residue, Judge, and there was no gun residue on Mr. Randall's hands.
Because it is a non-aggravated robbery, is what it is,
Okay,
what he's on probation for.
but
He was in the
still
car.
stealing out of breaking into vehicles and,
Multiple vehicles.
yeah. No. And then here we are, May 3rd, so less than a year after being placed on probation, riding around, smoking pot with a gun, and when you got taken out of the car, ran from the cops. No. Go ahead, you can make argument.
Judge, my intention was to come in and ask to follow the agreement for ISF. It doesn't appear that the court's willing to do that.
This is a turning point. And legally, it matters more than anything said before. What the judge is weighing right now isn't just the current charge, but the totality of circumstances. That includes prior criminal history, a pending robbery case in another city, and even behavioral reports from inside the jail. Here's a key legal concept. When a judge considers a bond reduction, the focus is not guilt or innocence. It's public safety and risk of reoffending or fleeing. And right now, the pattern being presented suggests repeated, similar conduct across multiple jurisdictions. Emotionally, you can feel the shift. The defense argues financial limitations and supervision options like...
I would point out that this is an offense that happened when Mr. Randall was a relatively young man. He's still a young man. He is the father of a young child. I think he's a 3-year-old. 9-month-old child at home, Judge. He is obviously making some bad decisions in his life, going all the way back to the original offense date. And that was why I thought ISF would be maybe helpful to him to give him some information to help him redirect his life, make better decisions in his life for himself and for his daughter. He's a pleasant young man. Every time I go talk to him, he's a really nice, pleasant to deal with. He's never had any blow-ups here in court that I can recall. He's had maybe some jail incidents. I think he threw some soap around one time and some wardrobe incidents. But other than that, I think he's been well behaved in jail. I would ask the court that if ISF is not going to be possible in this case, that you consider doing something towards the lower end of the punishment range. I don't know that. And again, Judge, I think that's why I think ISF would be better for him. We can send him to prison right now for whatever amount of time, but if he doesn't get the help and the education that he needs, he's going to come out and be the same way, even worse. So,
Judge, I'm sorry to cut you off, Mr. Ross. I'm showing that 2 new cases were received last week by my office concerning the exact same UCW and evading from July 13th, which is not alleged in the motion. If we need to amend to add those, or if you want to address those.
Another arrest?
That's what I'm showing, Your Honor. Two more pending, not yet filed misdemeanors for evading.
This is May 3rd.
Yeah, a different offense date. So if we want to take some time I don't have a probable
Absolutely.
cause available to me,
Yes.
but I can get that, obviously. If we can take a week or so to file an amendment.
Let's go ahead. I'll probably, just based on, court schedule, I'm going to, I want that back.
Yes, Your
I'll,
Honor.
let's reset it about 3 weeks. And if there is in fact a new arrest, I would like that.
Certainly.
In the
What I'll
motion.
do is file an amendment to reflect any new offenses or charges, Judge.
Yeah, that'll change everything potentially. So, yeah, let's see where we get with that. Go back with the bailiff. You probably need to talk to hey, Mr. Randall, also, you need to talk to Mr. Rojas. You need to tell him everything that's going on. He doesn't need to be surprised here in court. If you've been arrested again for something, y'all should be talking about that.
Thank you.
Thank you, Mr. Nichols.
1 through 8 are the same counts on each. 9 and 10 are different on each.
We have Craig, we'll agree to that and count 4. That's the 10. I'm printing the other one too, just because it's gonna be hopefully easier and hopefully it'll print. It should be on its way. All right, sir, in cause number 24, DCCR 1791, I also have a motion to revoke your unadjudicated probation. This one shows you were placed on probation September 24th of 2024 for theft of a firearm, a third-degree felony, and that was also a 5-year deferred probation. Is that correct? Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of unlawfully carrying a weapon May 12th of 2025 in Jefferson County, Texas, and is that true or not true?
True.
Count 2 in each case alleges that you committed the offense of unlawful carrying a weapon May 25th of 2025 in Jefferson County, Texas, and is that true or not true?
True.
Count 3 alleges that you committed the offense of a minor in possession of alcohol May 25th of 2025, and is that true or not true?
True.
And then the state is abandoning 4, correct? In each case. Count 5 in each case alleges that you committed the new offense of resisting arrest or transport May 27th of 2025, and is that true or not true?
True.
Count 6 in each case alleges that you failed to report as directed to the probation department February 10th and May 15th of 2025, and is that true or not true?
True.
Count
Just technical, so we can. if you want.
All right, state abandons 7 through 10 in each case.
No objection.
Did you enter your pleas of true in each case to counts 1 through 6? I'm sorry, minus 4. So 1 through 3 and then 5 and 6. Did you plead true to those freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached in each of your cases, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each
No
case.
objection.
It's admitted in each case. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true in each case freely and voluntarily to counts 1 through 3 and 5 and 6. Find those counts true. Find sufficient evidence in each case to find you guilty. In cause number 23, DCCR 1801, find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24, DCCR 1791, find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm, third-degree felony. Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of these cases trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you, and you need to listen carefully to this one because I'm not sure what's going on with you and all this gun stuff. Apparently you think it's cool to steal guns, have guns when you're not supposed to, and it's landed you now going to prison at, how old are you? 20 years old. You're going to prison because you can't keep your hands off guns, really. So because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you possess a firearm or ammunition, charges could be filed against you, and those charges are third-degree felonies. So it's no more UCW, unlawful carryings. It's a third-degree felony, felon in possession of a firearm, because you're now a felon. Do you understand? If you have questions about the laws.
This courtroom session delivers a clear message about how judges handle risk, responsibility, and repeat behavior. In the first case, the court ultimately denies bond reduction, not because of a single factor, but because of a combination of elements: the seriousness of the charge, the presence of a similar pending case, and concerns about ongoing criminal activity. Then, in the following proceedings, we see an even harsher outcome: probation revoked and prison time imposed. The judge emphasizes a critical point: repeated violations, especially involving weapons and evading law enforcement, eliminate opportunities for leniency. Legally, this
about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, I'm handing you the trial court certification in that document now. I'm also going to sign, as part of the agreement, a dismissal in cause number 25 DCCR 0868. All right, you can go back with the bailiff.